In California, once a trust becomes irrevocable, or once a new trustee steps into the office of trustee, the trustee is required to give notice to all the beneficiaries. And part of that trustee notice is what we call a 120-day notice. And what it means is that you as a beneficiary, once you receive that, you only have 120 days within which to contest the terms of the trust. And by contesting, I mean filing a lawsuit in court. So you only have 120 days to file a lawsuit to contest a trust once you get the 120-day notice. But what if you get a 120-day notice on a trust that's already been revoked before the settlor died? Under California law, if a trust has been revoked, the 120-day notice simply does not run. That's because the 120-day notice is only required to be given once a trust becomes irrevocable. Well, if a trust has been revoked before the settlor dies, then that trust will never become irrevocable because that trust simply no longer exists. The 120-day notice also must be given by the trustee, but if a trust has been revoked, there is no currently acting unauthorized trustee to give the notice. And for those reasons, a 120-day notice on a revoked trust does not apply. What that means for you is that you still might be able to challenge a trust even if you received 120-day notice if that trust was revoked before death. But of course you should never take chances because the 120-day notice is a bright line rule. If you don't file your lawsuit within that time period, you are forever barred from ever filing a lawsuit against that trust. So to play it safe, it's better to file a trust contest against any trust that you disagree with and that you have legal grounds to file against before the 120-day period runs.